In this video, we will refine our understanding of the parole evidence rule by delving into two important questions. First, when we have a written agreement, how do we know what level of integration it represents? And second, when is parole evidence admissible to resolve ambiguity in the terms of a written agreement? As to the first question, assuming we have a written agreement between the parties, how do we know whether the written agreement represents a full or a partial integration? For application of the parole evidence rule, this question is critical because in the case of a full integration, parole evidence is generally barred to supplement the terms of a written agreement with consistent additional terms, but in the case of a partial integration, such parole evidence is generally admissible. So how do courts tell whether we have a full or partial integration? This is a question that is not answered by the UCC. Instead, it is an answer that is found through the development of the common law of contracts. So this is a topic that you probably covered in your study of the common law. And because each state has its own distinct common law, in practice you will need to look up the common law of the jurisdiction that you are interested in. Broadly speaking, though, where all courts agree is that the question of integration is a question of law. The question of whether a writing represents a partial or full integration gets decided by the judge and not the jury. Where courts disagree, however, is what test to use to identify the level of integration. Two competing approaches have emerged from the common law. The older, stricter approach is known as the Four Corners Rule. Under the Four Corners Rule, courts look only to the writing itself. The court confines itself to the four corners of the written page or document to determine whether the document represents a partial integration or a full integration. Importantly, under this rule, the court does not consider the parole evidence itself. Instead, the court asks, does the writing on its face appear to be a total integration, a final, complete, and exclusive expression of the parties' agreement? Looking at the written document itself, the court might look to see if there are any obvious gaps in the written agreement, any material issues that are left unaddressed, any omissions to suggest that the writing is not a full integration. Or the court might look to see if there are any explicit references to any outside agreement beyond what is integrated into the writing. Any such reference would suggest that the writing itself is not the whole agreement, but only a partial integration. Most importantly, something that can be dispositive under the Four Corners Rule is the presence of a merger clause in the writing. A merger clause is also known as an integration clause or an entire agreement clause. Press pause now to take a moment to read this example. You may have encountered a clause like this before if you've ever reviewed a formal written agreement, and if so, you probably just glossed over it as meaningless legalese. But now, in the context of the parole evidence rule, you can provide a more sophisticated explanation of what this term means and why it's important. Press pause now to take a moment and think about it. What, in the language of the parole evidence rule, does a merger clause mean? A merger clause is essentially saying that the writing in which the clause appears is a total integration. The writing integrates all the parties' agreements and understandings. Stated differently, a merger clause says that if it's not in this written agreement, it's because the parties did not agree to it. Under the Four Corners Rule, the presence of a merger clause creates a very strong presumption that the writing is a full integration. The rationale for this rule is that it protects the sanctity of the writing. It promotes predictability and certainty for contract parties. For contract parties, the only thing they are legally bound to is what's in their written agreement and nothing else. The other, more relaxed approach is what I call the contextualist approach. It's based on the premise that a written agreement, no matter how complete it appears to be on its face, cannot be a full integration if there is credible extrinsic evidence to suggest the writing omitted a term to which the parties actually agreed to. Indeed, as we have observed from the outset of this module, two individuals, two contract parties, may have all sorts of understandings and agreements, but it's impractical, indeed impossible, to expect contract parties to write down everything they may agree to write down every understanding or expectation that they might share. To be sure, if they include a term in the writing, it's because they intended to be bound to that term, so parole evidence should not be admitted to contradict what's in their writing. But there may be other terms to their agreement that the parties neglect to incorporate into their written agreement. Thus, the contextualist approach begins with the premise that the written agreement, regardless of what it says, may not be the full sum of what the parties actually intended to be bound to. Therefore, under this approach, the court should look beyond the written agreement to the credibility of the parole evidence that one party is proffering to determine if the written agreement was a full integration. If the extrinsic evidence appears to be credible, then regardless of what the written agreement says, the written agreement cannot be a full integration. Note, the presence of a merger clause is still relevant to this determination. After all, the existence of a merger clause in the party's written agreement undermines the credibility of the extrinsic evidence claiming that the written agreement was in fact not the entire agreement between the parties. But under the contextualist approach, courts also recognize that merger clauses are a standard boilerplate term that may not actually reflect the party's intent, especially if there is credible extrinsic evidence that the written agreement was in fact not the entire agreement between the parties. Thus, under the contextualist approach, if the extrinsic evidence is credible, it suggests that the parties had agreements or understandings beyond what they reduced to writing. Stated differently, the extrinsic evidence credibly suggests that the written agreement is in fact only a partial integration. If the writing is only a partial integration, then the court should admit the extrinsic evidence and allow the fact finder, that is the jury, to weigh the credibility of the extrinsic evidence and make its own factual determination as to whether the parole term was in fact part of the parties' agreement. So, courts in different jurisdictions disagree about how to determine whether a written agreement is a partial or full integration. Now let's move on to the topic of ambiguity, where we will see that there is again a very similar disagreement among courts. The question here is, when is parole evidence admissible to explain ambiguity? The parole evidence rule primarily addresses when parole evidence is or is not admissible to supplement or contradict the terms of a written agreement. And that question, in turn, depends on whether the written agreement is a full or partial integration. But as we have already noted, the parole evidence rule always permits explanatory evidence to resolve ambiguity in the writing, regardless of whether the writing is a partial or full integration, so long as the extrinsic evidence is being used to resolve ambiguity and not really trying to add new terms to the party's written agreement or contradict any of the terms in the writing. When is a term in a written agreement ambiguous? First, let's be precise about what we mean by ambiguous. Ambiguity has a pretty well-established definition in contract law, one that you have probably noticed me using already. Ambiguity means when language is reasonably susceptible to more than one interpretation or meaning. So how do courts tell if the terms of a written agreement are ambiguous? Again, this is a question that is not answered by the UCC. Instead, it is an answer that is found through the development of the common law of contracts. So this is another topic that you probably covered in your study of the common law. And because each state has its own distinct common law, in practice this means that you will need to look at the common law of the jurisdiction that you are interested in. Broadly speaking, though, where all courts agree is that this is a question of law. The question of whether a contract term is ambiguous gets decided by the judge and not the jury. Where courts disagree, however, is what test to use to identify ambiguity. There are again two competing approaches that closely parallel the diverging common law rules that we just covered. The older, stricter approach is called the plain meaning rule. Under this rule, a court looks only at the written agreement itself, interpreting the language of the agreement by giving the language its plain and ordinary meaning. If the plain meaning of the written agreement is ambiguous on its face, what is called express ambiguity, then the court will admit extrinsic evidence to aid in clarifying the meaning of the writing. If, however, the court believes that the language is unambiguous, that there is no ambiguity, the court will exclude the extrinsic evidence that might potentially corrupt the meaning of otherwise unambiguous writing. But importantly, under this rule, the court will not look beyond the four corners of the written agreement to find ambiguity. The rationale is that if words are the best indication of the party's intent, why should we look beyond words to create ambiguity in the language the parties use where there is not ambiguity in that language? Comment 1C to 202 seems to reject the plain meaning rule, at least for course of performance, course of dealings, and usage of trade. Specifically, it definitely rejects the requirement that a condition precedent to admitting evidence of custom is an initial determination by the court that the written agreement is expressly ambiguous. The laxer approach that the UCC seems to favor instead is a more contextual approach. This approach begins with the premise that ambiguity is not always obvious when you consider only the plain meaning of words or language in a written agreement. that ambiguity may become evident only when you consider those words or language in the context that they were used. Stated differently, that ambiguity may arise only after you look at the extrinsic evidence of the context in which the expressed language was used. Consider, for example, a contract contemplating the sale of 2x4 lumber. The plain meaning of 2x4 lumber is lumber that is 2 inches by 4 inches, but that meaning lacks any relevant real world context. Specifically, because wood shrinks in the lumber and construction industries, it is commonly understood that 2x4 lumber is actually 1.5 inches by 3.5 inches. Stated differently, the term 2x4 lumber in a written contract may not be expressly ambiguous, but it has latent ambiguity. Ambiguity that only becomes apparent once you consider extrinsic evidence of the context in which the language was used. Accordingly, under the contextual approach, the court looks beyond the plain meaning of the words in the parties' written agreement. Instead, the court examines the words in the parties' written agreement in light of the extrinsic evidence one party is proffering. If the extrinsic evidence credibly suggests that the language in the written agreement is reasonably susceptible to more than one meaning, the court will admit the extrinsic evidence and allow the fact finder, the jury, to make its own determination as to the credibility of the extrinsic evidence and whether the words of the parties' written agreement meant what the extrinsic evidence suggests. So, in this video, we looked at how the common law of contracts supplements the UCC's parole evidence rule on two important questions. First, when we have a written agreement, how do we know what level of integration the agreement represents? And second, when is a term in that written agreement ambiguous and therefore parole evidence admissible to resolve the ambiguity? In the next video, we will conclude our look at the parole evidence rule by examining the exceptions, or more correctly, boundaries of the rule, areas that lie beyond the application of the parole evidence rule.